What we are discussing today could not be farther from being merely theoretical. With that, I will turn to the chairman.
Thank you. Senator Feinstein already referred to our panelists as distinguished panelists, and I've noted, my staff has noted for me, all the publications you've all done. And if I refer to every one of those publications, you'll never get a chance to give your remarks. So I'm going to give a relatively short introduction of each of you, but you can go to the record. Everything that is in my opening remarks will be in the record, so you know that I have absorbed that you are all well published and very distinguished in your professions. Our first witness is Professor Akhil Amar, Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law. He has also won awards from the American Bar Association and the Federalist Society, and is a recipient of Yale's highest award for teaching excellence. He has been favorably cited by the Supreme Court in over 30 cases. And then he has authored dozens of law-reviewed articles that I'm going to put in the record. Our second witness is Professor Eric Posner, the Kirkland and Ellis Distinguished Service Professor of Law, University of Chicago. He writes about and teaches legal theory and constitutional law, including the law of presidential powers. He has written more than 100 articles at academic journals and more than a dozen books, including 2 of the presidential power, one entitled The Executive Unbound, after the Madisonian Republic, and then he's published in various important newspapers and other articles, and those will be put in the record. Our third witness, Professor Stephen Vladeck, professor at the University of Texas School of Law. Senator Cornyn, I hope you weren't, I was going to introduce these folks. Was I supposed to give deference to you?
No, sir.
Okay.
Go ahead, Mr. Chairman.
Professor.
I'm glad to have somebody from the University of Texas Law School here today. We discussed FISA reauthorization in the line at Southwest Airlines yesterday in Austin. So, so I'm glad to have him here. Thank you.
Professor Stephen Vladeck, a professor at the University of Texas School of Law, where he teaches federal jurisdiction, constitutional, and national security law. His works have appeared in a variety of news forums and legal publications, including Harvard Law Review and Yale Law Journal, and the rest of that will go in the record. Our final witness, Professor John Duffy, Samuel H. McCoy, Professor of Law, and Elizabeth D. and Richard A. Merrill, Professor of Law at the University of Virginia Law School. He teaches tort, administrative law, patent law, and international intellectual property law. He has also served as articles editor for the University of Chicago Law Review, and was awarded the Olin Fellowship in Law and Economics. Professor Duffy, clerk for Judge Stephen Williams on the U.S. Court of Appeals for the D.C. Circuit, and for Scalia, served as attorney advisor in the Department of Justice Office of Legal Counsel, and practiced law at Covington and Burlington. He has also published much. The committee has also received a letter from Professor John Harrison, the James Madison Distinguished Professor of Law at the University of Virginia Law School. In it, Professor Harrison expresses his views that both of the bills that we are considering today would encounter significant constitutional difficulties, and that letter will be put in the record. We'll start with you, Professor Amar.
Thank you, Mr. Chair. It's an honor to be with you all. I've previously testified before this committee on half a dozen occasions, and it's a great privilege and always a solemn responsibility to be with you. The 2 bills under current consideration, the Graham-Booker bill and the Tillis-Coons bill, aim to thwart potential presidential abuses in connection with attempted removals of special counsels, including the possible removal of Robert Mueller. The bills have laudable goals, and it's heartening to see bipartisan sponsorship here. Several of the bill's co-sponsors are my dear friends. I have no such personal relationship with President Trump, whose wings the bills aim to clip. I'm a registered Democrat who publicly opposed Mr. Trump in the 2016 campaign, and I am distressed by many of the things he has done and aims to do. That said, I must sadly report that as a scholar who studied the Constitution, I believe that the bills in their current form are unwise and unconstitutional. It gives me no pleasure to say this, but I need to be straight with this committee. Happily, I think there are alternative reforms that actually are more constitutionally proper and more likely to actually achieve the laudable purposes of these bills, to restrain improper presidential behavior. In a nutshell, I think that the bills are, if enacted, likely to be successfully vetoed, are likely to be judicially invalidated, and are in any event violations of several basic constitutional principles. So my preferred alternative, in keeping, Mr. Chair, with what you said, the one thing we can all agree on, you said, is that there's a robust role for Congress in overseeing the executive branch, and I actually think that this body itself has more resources and would be advised to use some of its own cameral powers than to try to punt things over to the judiciary in the way that these bills try to do. In a nutshell, if the bills were to reach the president's desk, I think he might be very inclined, of course, to veto them. That's going to be hard to overturn. Only twice since 1952 has a president who controlled both houses of Congress had his veto overridden. He's likely to be backed by an OLC memo, by a broad range of public opinion leaders. He will claim that he's defending the presidency more generally, and various public opinion leaders, I think, would back him up on that, and it would boomerang. Instead of actually chastening him and checking him, this would actually, unfortunately, empower him. Were the issue to reach the courts, and I think there is a disagreement among these very distinguished panelists, I count 6 likely votes for invalidation. And we can go through my reasons for that in more detail if the senators are so inclined, and that too would actually end up boomeranging and backfiring rather than accomplishing the need to chasten and check this president or any president who is tempted to abuse power. In a nutshell, the Constitution says that someone like Robert Mueller, who's not confirmed by this body, is constitutionally an inferior officer. It is very hard to be both inferior and independent at the same time. It's like a square circle, and these bills try to make someone who is inferior also independent, and constitutionally that's a problem. Technically, the reason that he's independent right now is he actually can be sacked. He can be fired within the executive branch. Here I channel many of the things that Justice Scalia said in his most famous opinion, the Morrison versus Olson opinion, but I go beyond that, and my written testimony is, of course, available to you all. Now, my proposed alternative, in the spirit of the Federalist 51, is to actually have a standing bipartisan committee of this body, equally balanced, like the Senate Ethics Committee is, a standing committee on presidential oversight, and this committee would aim to basically institutionalize a true separation of powers rather than a mere separation of parties. You wouldn't be acting as Republicans and Democrats as such, but you'd be acting as senators checking the executive. You'd be channeling the best thing about these bills, which is their bipartisan structure. Instead of punting things to the judiciary, and I know my time is up, you'd be emulating the judiciary at its best when, in McCulloch, Chief Justice Marshall reaches out across the aisle, and Sebelius, John Roberts reaches out across the aisle. You could be doing actually what the judiciary has done at its best, Earl Warren in Brown, rather than punting things to the judiciary itself. Thank you, Mr. Chair.
Thank you, Professor Amar. I should have told all of you that your full statement will be put in the record. You've probably been told that, but I want everybody to know that 5 minutes is a short period of time for all of you folks that write so much, so it'll be put in the record. Professor Posner.
Good morning, Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee. Thank you for providing me the opportunity to testify in special counsels and the separation of powers. I've evaluated the two bills under consideration today, and I conclude that they do not violate the principle of separation of powers, but on the contrary, advance important constitutional values. Now, Senator Feinstein has mentioned the Saturday Night Massacre to us, and I want to bring this a little bit back to life, especially for people who were young, as I was when it took place. On Saturday, October 20th, 1973, President Richard Nixon ordered the Attorney General to fire Archibald Cox, the Watergate special prosecutor, who had earlier issued a subpoena for the Watergate tapes. When Attorney General Elliot Richardson refused and resigned, the President ordered Deputy Attorney General William Ruckelshaus to fire Cox. The Deputy Attorney General also resigned rather than carry out the President's order. The President then asked Solicitor General Robert Bork to fire Cox. Worried about a leadership vacuum in the Justice Department, Bork swung the axe. The Saturday Night Massacre converted the long-simmering political crisis over Watergate into a full-blown constitutional crisis. 4 years after Nixon's resignation, Congress passed the Ethics in Government Act of 1978. A provision of that law created a new kind of special prosecutor, later called the independent counsel, who could be fired only for good cause, was given significant operational independence, and was appointed by a panel of judges. A major goal of the statute was to ensure that a constitutional crisis, like the Saturday Night Massacre, would never occur again. The law accomplished the roughly 20-year period it was in effect, despite the recurrence of significant controversies over executive branch wrongdoing during the Reagan and Clinton administrations. Congress allowed the independent counsel provision of the Ethics in Government Act to lapse in 1999. Critics had argued that the law created too many independent counsels who spent too much money investigating unimportant matters. The question today, however, is not whether to revive the independent counsel, but whether to give special counsels selected by the Attorney General and subject to Department of Justice regulations, which is why they are inferior officers, protection from removal except for good cause. Over the years, many people have raised questions about whether Congress is allowed to put limits on the President's authority over law enforcement. They argue that such limits on the President's executive power violates the principle of separation of powers. The Supreme Court decisively rejected this argument in a case called Morrison v. Olson in 1988. In a 7-1 decision, the court ruled that the independent counsel law did not violate the separation of powers. The reason was that the law did considerable good by enhancing the integrity of investigations of the executive branch, while it only modestly restricted the President's executive power. Since the bills under consideration today restrict the President's power far less than the independent counsel law did, these bills passed constitutional muster as well. Now, not everyone agreed with the Supreme Court's opinion. As Professor Amar noted, Justice Scalia, the single dissenter, wrote a powerful opinion that has won much praise. But there are good reasons why Justice Scalia did not persuade any of his colleagues. First, Justice Scalia claimed that the Constitution gave, quote, complete control over law enforcement to the President, and so any attempt by Congress to influence law enforcement violates separation of powers. However, this was not the understanding at the founding, and it is certainly not true today. The Constitution itself gives Congress power over law enforcement explicitly in the text, through appointments, and its power to define offices, its power to control budget as well, and Congress has used that power over the years in many ways. Second, Justice Scalia claimed that an independent counsel is unaccountable. He cannot be punished for misusing his power. Meanwhile, the President can be. As Justice Scalia put it, the President is directly dependent on the people, and since there is only one President, he is responsible. The people know whom to blame. But the Watergate burglary was an act of political espionage, one of many that helped President Nixon win re-election in 1972. The people could not punish Nixon at the polls because they did not know about the lawbreaking. Securely in power, Nixon pursued a course of obstruction of justice that may well have succeeded were it not for the inadvertent discovery of the tapes. Let me conclude. The idea of separation of powers is that each branch should check another branch if the latter abuses its power. Watergate showed that the executive may abuse its power by refusing to investigate its own law-breaking. Congress's constitutional obligation is to check the executive branch by providing a means for ensuring that an investigation takes place and is done fairly. The Special Counsel Independence Act and the Special Counsel Integrity Act take an important step in this direction. Indeed, they will more likely enhance executive power than undermine it because they reassure the public that the officers of the executive branch, including the President himself, are not above the law.
Thank you, Professor Posner. Now, Mr. Vladeck.
Great. Thank you, Mr. Chairman. Senator Feinstein, distinguished members of the committee, it's an honor to be back before you today. Rather than rehash my written statement, I'd like to take my time this morning to make 3 points that hopefully help to crystallize the areas of disagreement among the witnesses. So first, with regard to the current special counsel regulation, I hope you'll forgive me if I refer to it as Part 600, it's worth highlighting what I see as the major ways in which it's far less intrusive vis-a-vis executive power than that which was true about the independent counsel statute. First, under the regulation, the power of appointment belongs to the Attorney General, or as in this case, the acting Attorney General in cases in which the Attorney General is recused. There's no judicial role in appointment or in the initiation of an investigation, contra the independent counsel statute. Second, if there are concerns about the scope of the investigation, if the special counsel seeks to enlarge his jurisdiction, if the Attorney General is concerned about whether the investigation is going too far afield, the Attorney General makes the final decision about any questions of jurisdictional scope. That matter, too, is not subject to judicial review. And third, with regard to removal, Senator Feinstein already pointed out the regulation specifically provides that it is the Attorney General, again, or in this case, the acting Attorney General, who makes the removal decision, again, in contrast to 3 judges of the Special Division of the D.C. Circuit, as was true under the Independent Counsel Statute. If the largest concern folks had with the Independent Counsel Statute was the specter of a runaway prosecution, which many think we saw in the 1990s, there really is no meaningful chance of that under Part 600 as it's currently drafted. My second point, with regard to the 2 bills, I'd like to underscore how modest they are against that backdrop. So if we recall, during the Saturday Night Massacre, there actually was a lawsuit brought on behalf of Special Counsel Cox seeking to enforce the then-in-place regulation and contest whether he was lawfully removed. That did not require special legislation from Congress. That was a declaratory judgment and injunctive action. And Judge Gassell ruled that, indeed, then Solicitor General Bork had violated the then-in-place regulation by removing Special Counsel Cox. There's already a mechanism in place for a special counsel or someone to sue on his behalf to challenge wrongful removal. As tweaked, both bills simply guarantee that review and improve it by invoking a 3-judge district court and the automatic right of appeal to the Supreme Court that comes with it. And my third point, with regard to the Supreme Court's jurisprudence, which I gather is perhaps the principal point of departure between the 4 of us, the claim that Morrison versus Olson is bad law is, to me, simply unsupported by the record, in contrast to the widely held view that aspects of the independent counsel statute were simply a bad idea. I think we too often conflate those who think statutes were bad policy with those who assume they must therefore have been unconstitutional. Indeed, I disagree with my colleague and mentor, Professor Amar, that there are 6 votes among the current justices to overrule Morrison. I'm not sure how you even get past 3. Even if there's less support for Morrison, though, let me go back to my first 2 points. These bills are so much less intrusive than the independent counsel statute was. The real concern that they seem to animate is with the regulation itself. And I'm hard-pressed to see why these would be the vehicle through which the current court would seek to revisit prior precedent, given that all the bills do is guarantee a right to judicial review that may very well already exist. In closing, Mr. Chairman, let me just sort of turn back to Justice Scalia's Morrison dissent. I think Justice Scalia's dissent is rightly celebrated for its style, for its passion, and for how well written it is. But that doesn't mean he's right. And instead, I actually think I'd use a quote from the end of his dissent to point out the importance of this whole enterprise. Justice Scalia closed his Morrison dissent by reminding everyone of the text of Article 30 of the Massachusetts Constitution of 1780 and the maxim that ours is a government of laws and not of men. It seems to me that the special counsel is an important if limited, manifestation of that really important principle, and that ensuring a mechanism for protecting the special counsel from wrongful termination is, at a time when we very much need it, simply further to that laudable, desirable, and hopefully bipartisan goal. Thank you, Mr. Chairman. I look forward to your questions.
Thank you very much. Now, Professor Duffy.
Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee, thank you for inviting me to testify before you today. My analysis today is necessarily tentative because the Supreme Court precedents on the removal issue have not been consistent. Indeed, the court seems to have a curious habit of abandoning its own reasoning whenever it confronts a new major case in the area. In the court's 1935 decision in Humphrey's Executor, it abandoned the reasoning of its decision just less than a decade earlier in the Myers case. In 1988, the Morrison versus Olson case explicitly threw overboard the entire reasoning of the Humphrey's Executor case. And in 2010, the Free Enterprise Fund case did not quote or apply the functional analysis endorsed in Morrison. The holdings in all four of those cases remain good law, at least currently. But not necessarily any of the reasoning. With such judicial variability, I have to balk at making definitive predictions about the court's future course, which I think is a fair point. Turning to the bills, 1735's proposed transfer of removal authority from the executive to the judicial branch seems unconstitutional if the court adheres to the Free Enterprise Fund holding. Under 1735, a special counsel would enjoy statutory tenure protection unless and until the Attorney General could convince life-tenured Article III judges that the counsel should be removed under one of the statutory grounds for removal. That removal system seems to impose two levels of statutory tenure protection between a special counsel and the president. Under Free Enterprise Fund, such multi-level protection is unconstitutional. Indeed, the removal system under 1735, to the extent it differs from Free Enterprise Fund, presents additional problems that militate even more clearly against sustaining its constitutionality. I believe, however, that 1735 is directed toward a legitimate policy goal, which is to provide an orderly process to test the legality of a removal order without the brinksmanship of a disruptive removal order of uncertain legality, such as the one issued in the so-called Saturday Night Massacre. I think that the proposed legislation could be modified so as to be constitutional if it were to require that any order of removal not take effect for a period such as 14 days, to borrow the period from the other proposed legislation. To preserve the executive's prerogatives, the legislation should also provide that the special counsel's authority would be temporarily suspended during that period of time. That 2-week period would provide time for seeking judicial review and for the court to grant any appropriate preliminary equitable relief. Legislation requiring such a process would be well within the mainstream of existing precedent and broadly consistent with the existing practice in administrative law. With respect to S. 1741, the most constitutionally troubling aspect of the bill is that the combined effect of sections 2B and 2E would together change the regulatory tenure currently afforded to a single known officer into statutory tenure. There are no clear precedents supporting such a retroactive grant of stronger tenure for an existing officer. In my written statement, I cover certain analogous precedents that suggest that such a retroactive strengthening of tenure might be unconstitutional. Furthermore, the selectivity of the section, the targeting of a single official, makes the provision look more like an unconstitutional attempt to circumvent the executive's power to control appointments for particular offices. I recommend that the retroactive provision be deleted, or if it is maintained, that the subsection be made separately severable. In the event that the court holds Section 2E, the retroactivity provision, unconstitutional, a severability clause would allow the bill's procedures to be used for other legal challenges, such as the challenges heard in the Nader versus Bork case that was mentioned by my colleague here from Texas. One last point. The mandatory reinstatement remedy in Section 2D3 goes beyond the remedy allowed in prior Supreme Court cases and even beyond the remedy authorized in the Independent Counsel Act. I recommend that that section be modified to track the Independent Counsel Act and give power to the court to grant reinstatement or other appropriate relief. Thank you for your time and attention to these issues, and thank you again for the invitation to speak to the committee.
We will have a 5-minute round for questioning to Professor Duffy and Amar. As you know, both bills codify regulations on for-cause removal and permit judicial review. In your opinion, are either of these steps necessary for Congress to ensure that the special counsel investigation is conducted properly, or are Congress's oversight and impeachment powers enough? Start with you.
I believe that it is that the change from regulatory tenure to statutory tenure is not needed if you're asking the policy question of whether the regulatory tenure would be sufficient to ensure a degree of independence for the special counsel to conduct the investigation. That regulatory tenure, I think, is likely to be respected by the Department of Justice officials, except and to the extent that they begin to see difficulties or conflicts of interest or other causes that might require removal. And that information is likely to be closely guarded inside the Department of Justice because it will deal with the operation of the investigation, which is matters not really public, not known to generally to the members of the public.
Okay, Senator Amar, or Professor Amar.
I'm a fan of congressional oversight, and I think it's actually a better mousetrap than trying to make a statute that codifies the good cause removal standard. One thing that makes the good cause removal constitutional at present is, from a formal legal point of view, it could be rescinded by the executive branch. So the executive's choosing to bind itself, and that's part of what makes Robert Mueller technically an inferior officer. But if you put it in a statute, how is he actually constitutionally inferior? Cabinet officers can be fired at will, and yet this person, can't be, and he's supposed to be inferior. The Morrison case, you had Alexia Morrison investigating one person who was out of office, Ted Olson. So maybe that person was inferior. Here, you've got someone investigating the President of the United States for possible obstruction of justice and finding the director of the FBI, as well as other people possibly involved in a major national scandal involving alleged Russian tampering with a presidential election. Oh, it's hard to say that that person is actually in any way inferior if you actually statutorily require these limits on removal. Again, cabinet officers are superior, the principal officers, and they can be actually fired at will. And there's the pardon power that interacts with all of this, which is an important element. Congressional oversight by this committee or a standing committee of some sort, I think, is the far preferable way to go.
I have another question that's a little bit out of the purview of this hearing, but very central to oversight responsibilities of this committee that I'd like to ask you if you could comment on it, each or all of you. According to recent press reports, Deputy Attorney General Rosenstein has been interviewed as a fact witness by Special Counsel Mueller's office. He reportedly provided them a copy of the President's initial memo justifying the removal of FBI Director Comey and was questioned about it. Do you believe that poses a conflict of interest, and should Deputy Attorney General Rosenstein consult the ethics officials at the Department of Justice about the issue? If you could comment, I'd like to have your opinion.
I haven't investigated that sufficiently to give you actually a good answer, Senator, Mr. Chairman.
Is that the same for all of you? Yeah. Okay. Then let me move on. That's something, though, that's very bothersome to this committee. I want to bring that up. For Professor Vladeck, Posner, and Amar, S-1735 requires the Attorney General or Acting Attorney General to submit his removal decisions to a 3-judge panel, making a finding that the removal of special counsel is appropriate under 1735 for cause provision. 1741, on the other hand, permits the special counsel himself to seek review of any removal decision. In your opinion, is the approach taken by 1735 or 1741 preferable from a constitutional perspective?
I'll take that first, Mr. Chairman, because I addressed that a bit in my written testimony. I think it would be safer to take the approach where the initiating complainant is the special counsel. Let me just illustrate that with a hypothetical. Imagine a case where the special counsel doesn't even contest that the Attorney General, in fact, has cause for his removal. I don't know what is gained by having the Attorney General go through an unnecessary judicial process. So I think it's not necessarily a violation of Article 3 to have the Attorney General go first, but I think it makes a lot more sense